Costs are recoverable by a party in whose favour the award of costs is made. And the normal rule is that if a party is completely successful in the action, they'll get all their costs paid by the losing party. But there are obviously variations to that rule, so that, for example, even a successful party may find that they will have to bear their own costs in part, or indeed pay part of the cost of the losing party if they have done something like caused costs to be incurred unnecessarily. For the most part, recoverable costs are those that are necessary for the purposes of the proceedings. And in a temporal sense, that covers the costs incurred prior to the commencement of litigation when the party is gearing up to commence the litigation. However, in at least one case, the cost of obtaining legal advice as to the chances of success for a future action were not recoverable. And in a temporal sense, the recoverable costs include all those incurred during the course of the proceedings up until the end of the oral procedure, that's to say, the end of the hearing, because it is at that point that a party's active role in the proceedings normally comes to an end. So in a temporal sense, the recoverable costs are those that are incurred in the preparation of the case, right through the case and up until the end of the hearing. Typically, recoverable costs are divided into disbursements and legal fees. Disbursements are normally recoverable fairly easily. In relation to certain expenses like office, secretarial and telecommunications cases, it's normally the case that you can recover a global amount or a fixed rate up to and not exceeding about 5% of the costs of the party's own lawyer. In other cases, disbursements are recoverable if they are proved and justified by the production of invoices. So, for example, if a lawyer has to go to Luxembourg to attend a hearing, then the cost of an overnight stay in a hotel and the cost of travel to and from Luxembourg needs to be proved by producing an invoice from the hotel, the flight ticket and so forth. If the lawyer decides to go to Luxembourg under his own steam, then you can use as a proxy the cost of a ticket under a readily available public means of transport, such as a railway train. Lawyers' fees are perhaps the more tricky area. The court isn't concerned with how much the successful party ought to pay his or her own lawyer. It's concerned with what the party ordered to pay the costs ought to pay. And here what the court does is to apply its own judgment as to what is an appropriate level of legal fees that the successful party can claim from the losing party. The court doesn't apply any national criteria for fixing fees. There are no standard rates. It applies its own judgment. And typically it will apply criteria such as if it's presented with the fees of a lawyer who is supposedly an expert in the relevant field, it will start off on the assumption that if he is an expert, then he's going to take less time to prepare the case than somebody else. And it will look closely at the number of hours worked and may well reduce them because it takes the view that an expert will simply act, or rather operate, more efficiently and will take up less time than another lawyer. The result is that if you are awarded the costs, you'll probably get back all disbursements, but it is unlikely that you will, or you can't assume that you're going to get back the entirety of the legal fees that you owe to your own lawyer.